Good afternoon, everyone. Thank you for joining us this afternoon. Those of you who don't know me, my name is Stefan Besaidnout. I'm the Chief Executive Officer of the Ethics Practitioners Association. And to those out there that I do know, welcome. Nice to see you again. I see there's quite a few that have joined us. So welcome at this session this afternoon. This session is in continuance of our very successful webinar series that we've been holding lately. I mean, obviously, given the lockdown in various kind of forms and formats, we thought this is the most appropriate and probably the most effective, given the geographic locations of our members, most effective way to keep in communication with our members and to add value to the knowledge base and skills base to our members. So who we have today is someone very special. I want to introduce you to Johanette Rheeder. Johanette Rheeder is an attorney and the founder of Johanette Rheeder Incorporated, and she's going to talk to us today about privacy and the latest developments specifically around POPIA and some interesting concepts around how ethics practitioners, or those of us who find ourselves working in the ethics space or the ethics management space, how these new regulations and these new requirements we can fit in our responsibilities and how we operate in our respective areas every day. So Johanette, who's well qualified, I mean, she's got a BLC, LLB, LLM. Johanette, I think it's time for that LLD. So she has more than 27 years of experience in law and specializes in privacy law, labor law, contracts, and commercial law. So we couldn't have asked for someone more appropriate, more qualified, and skilled to talk on the topic. And Johanette, my understanding is you've got a presentation that we're going to start off with, where you're going to share with us some of these thoughts. So I'm going to hand over to you. And then should there be time left at the end, you know, I'm happy to discuss a few issues with you and maybe take some questions from the floor. And, you know, and then we can conclude. So without further ado, I'm going to hand over to you and welcome and thank you for your time.
Thank you. Thank you, Stefan, and thank you for having me. I really appreciate that. This was an interesting preparation to do. I often deal with the law and often with the investigations and the ethical side thereof, but we don't always think about the ethical side. We tend to, as lawyers, just run to the legal solution and the legal side, and we sometimes miss out on the ethical side of what people do and tend to just look at whether it's legal or not. And during the course of my research, I again realized there's such a fine line between the value that an ethical practitioner and ethics in a business can add in order to assist employees, employers, organizations to be a good corporate social citizen. And POPIA, as you're going to see today, I'm strongly going to advocate that POPIA is compliance, yes, and we all run to IT and we all run to the lawyers and to risk and compliance to implement POPIA, but we forget about the fact that POPIA in its essence, in my view, is a piece of social legislation. It is about our social responsibility as a corporate citizen, as well as an individual when we process the personal information of somebody else. Whether it is now a natural person or whether it's a legal persona, and sometimes when we deal with law, I always tell people just take it and turn it around and personalize it to you and ask yourself, how would you feel if somebody do this to you? So we very often process personal information, but when somebody wants to process our personal information, then we say, well, you cannot do that. You may not do that. And I see that we are in POPIA flutter since POPIA came into operation on the 1st. And everybody is saying, you can't process my information because you need my consent. And that is not exactly how POPIA operates. Yes, consent is very important, but if you put the message out there that you cannot process personal information, you need consent before you process personal information, you are not on the right track when it comes to POPIA. And that is where, in my view, the ethical part of it becomes extremely important, because POPIA does not say you may not process personal information. POPIA says that when you process personal information, there are certain conditions applicable, specifically the 8 conditions. Obviously, there are instances where the processing of personal information will become prohibited in terms of POPIA, but it's very limited. And that is very important, that when we start talking about POPIA and the implementation thereof, we need to start looking at how do we process the personal information of a data subject. And that is where the ethical part thereof becomes so important. The transparency of what we do, the participation of the data subject, the notification to the data subject, and also what do we do and how do we make sure that when we process the personal information, we act in an ethical manner as well. So moving on to the next slide, which I'm trying to do. If you look at, and I went to look at your website, and your website says to us that the EPA aims to be the recognized professional body for ethics practitioners. And the purpose of the association is to promote the professional status, the image and the credibility of its members, and provide accreditation, best practice, principles, conduct standards, and be a body of knowledge for its members. Now, in that, you have the core value also of what you can instill in an organization, because your status, your image, and your credibility as an organization is also extremely important. And as a privacy practitioner, in my view, that becomes the core. If you look at the functions of ethics practitioner, it is to advise, to guide, to assist, and to facilitate an ethical culture in your organization, and to be the watchdog and to be the voice in an organization as to when do you act on an ethical basis, or when are you straying into the dark side of unethical behavior. And very often you would find that your unethical behavior would then also result or be in itself criminal behavior or exposing your organization to criminal or civil liability. So I've looked at a little bit of an example, and obviously the first example that came to my mind is, am I going to talk to you about ethics in the political arena? We're so well aware of what's happening in the political arena, and I thought, no. You know what? We've spoken about that. We've done that to exhaustion. I'm not going to use that as an example. And I thought, let's go closer to home and ask ourselves, in our environment where we are today, and the new normal, because we cannot get away from COVID at this stage, and the new normal, in my view, is not going to change. So the new normal in ethics, in a specific example, is what I want to talk to you about in the environment where you also work for a company and you need to be the watchdog also about this. So how does this pan out, specifically in the instance where we work from home and employees work from home? And you as ethics practitioners will know probably better than I do that if you put a person in a work environment, the way that they operate in that work environment where we are all together, there are rules, there's regulations, you're under the eye of your manager, you've got the herd is all in one arena, then you act differently when you're sitting at home, where nobody is watching you, when you're working on your computer, where you're dealing with the work ethics and the practices of the employer on your own. And sometimes it's much more difficult for the individual to live out those ethical values and those practices of the employer, where they're sitting at home or where they're dealing with people from a remote area. So I thought let's look a little bit at what's closer to home and what has been happening. We all know that the cyber attacks has increased exponentially subsequent to the COVID lockdowns that we have experienced. And we in South Africa is not foreign to the fact that we have been immensely threatened by cyber attacks as well. So if you look at this scenario that I'm going to set to you, I want us to look at how far does the underlying legal reasoning go that a company's rights and interests outweigh an employee's right to privacy when the employee is using company-owned equipment. So we sit with a scenario where the employee is sitting at home, the employee is using a USB, the employee is using company communication structures, a cell phone. We all have got little WhatsApp groups with employees and colleagues. And if you're in a marketing environment, there's a WhatsApp group for your clients and your suppliers. And how do you use this? Because before we know it, our personal views and our personal opinions and our personal conduct sort of spills over onto this, these platforms of an employer. And how far does the employer's liability then stretch toward a data subject whose PI has been compromised as a result of an employee sitting at home doing something, either acting blatantly criminal in doing so, or acting just on an unethical basis, or exposing the company. Now, Section 99 of POPIA, for instance, regulates the conduct when it comes to civil liability in terms of POPIA. So interesting enough, I don't know whether you're aware of that, but Section 99 allows for a person, a data subject, to sue a responsible party for a privacy incident or a privacy violation. And very importantly also, that that person can approach the regulator and ask the regulator or apply to the regulator to institute legal action on his or her behalf. So you would find that you are much more exposed as an organization as a result of that, because the regulator might say, this is a type of class action or a type of action that we think is important. It is in the public interest to do so, and I will take on this case. For instance, Gogo Glamini, you remember a few years ago with the SASA issues that we had, where the elderly were exposed and the elderly were exploited. There might be an instance where Gogo Glamini does not have the funds to go to the High Court or a magistrate court and execute her legal rights against the responsible party. Now the regulator can step in, and the regulator can litigate on behalf of a person, whether it's a natural person or a legal person. And interesting enough also, you are liable for the conduct of, as a responsible party, whether it was on a negligent or an intentional basis. So it's not only intent that is regulated by Section 99. The court can then also grant punitive damages against a responsible party for the violations. And you will see later on, when we talk about the test that's applied by the court and the regulator, how the role of the ethics officer, in my view, becomes or come together in assuring that you do not get these criminal liabilities or the violations or the fines or the civil liability rolled up against your company. So another interesting question that came about is, with these employees that sits at home, say for instance now the employee is disgruntled. We all know this scene where a disgruntled employee is now starting to act out and lash out against the employer. And say for instance this employee sits at home on a Sunday afternoon, doesn't have much to do, and has got access to the company server because of the fact that this person is in IT or in compliance. And this person then decides, well, this is now my time to get back as this employer who had done me wrong. And he then downloads about 1,000 or 100,000 of the employees' data, payroll data, bank account numbers, and so forth onto the internet. He then sends a message, because he wants attention, he sends a message to media houses and say, I am actually a concerned citizen who came upon this information on the internet, so I want to make you aware of this. Luckily, what happened is that the media houses then alerted the employer. And this is exactly what happened. I will come back to this slide. This is exactly what happened in the Morrison Supermarkets case in Britain. Now, Morrison Supermarkets operated as a chain of supermarkets and employed Mr. Andrew Skelton on its internal audit team. And he received a verbal warning after a disciplinary proceeding for a minor misconduct. He then got disgruntled and he published payroll data of 100,000 of Morrison's employees on the internet. Now, lo and behold, after the newspapers did not want to publish the information, they alerted Morrison's, and Morrison's contacted the police. Skelton was then arrested and prosecuted and imprisoned. And we might think, well, this is the end of the story. The crook has been apprehended, and Morrison acted immediately as a good responsible party, and they mitigated the damage. They took that information off the internet. So you would think, is that the end of the matter? Well, it was not the end of the matter in this specific instance. What happened here is that the data subject says, but our payroll information and our bank account numbers was now published on the internet for every hacker and every person to see. And we are actually suffering damages. Now, I don't want to go against Mr. Skelton because Mr. Skelton lost his job. He's in prison. He does not have any money to pay me. But you know what? This employer of mine is an employer of substance. So they went against the employer. And what happened here and caused huge flutter, especially for the legal people, is that the principle of vicarious liability were applied here on the employer. And vicarious liability kicks in when an employee acts in the course and the execution of his or her duties. Then the employer can be held liable for a damage to a third party as a result of that. Similar, your violation of your privacy rights and the damage you might suffer as a result of the violation of your privacy rights. And the court, the High Court here in Britain went and said, oh, but regardless of the fact that Mr. Skelton acted in a criminal manner, you, employer, are still liable. And the High Court there held the employer liable for this privacy violation that took place, notwithstanding the fact that Mr. Skelton did not act within the scope of his employment when he did that. He was sitting at home on a Sunday afternoon and he disclosed it from his personal computer. Now, the matter went to the Supreme Court and to the Appeal Court, first to the Appeal Court and then to the Supreme Court in Britain. And in the Appeal Court, it was upheld. Luckily, it was overturned in the Supreme Court. And this precedent in Britain now confirms again that an employer can be held liable for in terms of vicarious liability for the conduct of an employee that is committed during the course of the employee's employment whilst performing the actions of an employee. So there must be a causal link between the two. But for a while, we were quite apprehensive about this because of the fact that our international precedent, which Popeye looks at, that was applied here, would say that even the criminal conduct of your employees will be brought to your door. So you see how this can pan out so quickly into a legal consequence. So here we started off by saying, well, you abused your communication privileges by linking up to the company server, and your productivity might have decreased, which we can deal with in terms of disciplinary measures. But what happened here also is now it's 100,000 people. It went to the newspaper. So now you start with reputational suffering as a result of the conduct of this employee. Then you entered into legal problems where you had to go all the way through the High Court, the Appeal Court, to the Supreme Court in order to vindicate your right as an employer to say, I'm not held liable for the criminal conduct of an employee. The employee did not act within the course and scope of his employment when he did this. He did it on a frolic of his own. And this company had to wait for the Supreme Court in order to confirm before that happened. And all the while, you're sitting with 100,000 disgruntled employees whose information was on the internet. You're sitting with reputational damage here. And yeah, productivity also obviously loses also if people are busy with other things at work that they were not supposed to do. So is the solution now to strictly monitor your employee communications? Because if you strictly monitor your employee communications, slap bang into the framework comes POPIA. Because monitoring your employee communications, especially where those communications are of a private nature, or where the communication is of a work-related nature, but there are private views in there, that constitutes personal information in terms of the definition of POPIA. And now you need to protect that information. And this is where people say, no, sorry, you cannot process my personal information. And this is where POPIA says, no, I can process the personal information because there will be an exclusion if I do not have consent. For instance, the exclusions relate to your legitimate business operations. It relates to your right to do so under contract or under the law, or where the person willingly makes this information known in the public sphere. But very importantly, and this is where ethics comes in, is I might not need your consent. I am allowed to process your personal information. I do not necessarily need your consent because I've got a legal or a contractual right to do so, or I've got a business operational right to do so. However, how much duty or how ethical is it for me to process your information, not to make you aware of the fact that I'm processing your information and not wanting to give you access to your information, and telling you that you must monitor, or that I am monitoring your communications, for instance, and making you aware of the fact that if you publish your personal views on company communications, for instance, that I will be monitoring it and that I'm entitled to do so, and you have a right then not to make your personal views known on communications, because you know that as an employer, I am actually monitoring your communications. So here the ethical part of your behavior as an organization becomes very important, and it's an extension to your legal obligation as an employer, as well as your legal right as an employer to protect your interest as well. So very importantly, what do your ethics and your privacy policies say about this? And this is where you as an ethics practitioner comes in to make sure that your ethical policies and your statements out there also comply with the or make sure that an organization complies with its duty in terms of POPIA. Now, Mr. Morrison is in jail, and hopefully Mr. Skelton is in jail, and hopefully Morrison Supermarkets were able to mitigate their reputational damages that they have suffered here. So if you look at the privacy compass, or you look at how this pans out, we always talk about our moral compass that we also apply, and your morals are very, very closely related also to your ethical behavior. When it comes to privacy, you will see that the law, specifically in this case POPIA in section 99, allows for a responsible party to be held liable on a civil basis. You can also be held criminally liable. You probably all aware of the fact that you can go to jail for certain violations. And this is now, can't put the company in jail, but you can put the information officer who bears the statutory duty of accountability in jail. And that can be anything between 12 months and 10 years, depending on the violation. Similarly, you can get a fine up to 10 million rand. And we've now, I see that it's also often referred to as downstream liability or your vicarious liability. So how far do you stretch the liability in terms of your risk as a company downwards? So the responsible party and the conduct of its employees, and as well as the conduct of people suffering damages as a result of this. Your accountability, obviously, as an organization is filtered down onto the shoulders of the information officer. We will talk about the information officer just now. And also compliance. As an ethics officer, you are also probably very much interlinked with compliance. And this is the second leg of privacy. It's a social, POPIA is a piece of social legislation, but it's very much also compliance, complying to certain processes, complying to the 8 conditions of POPIA. But how we do that and how we execute that is very much an ethical question as a responsible corporate citizen. Your reputation is at this stage damaged. We all know about all the issues that took place with regard to insurance companies. If I ask you today whether you, after that security breach to about 2 years ago came about, whether you considered declining or deleting your policy or cancelling your policy, and whether you would go and take out insurance with that specific insurance company. People laughed when I asked that question. They said, no, obviously, that's a reputational damage that you suffer as a result of that. Your competitive edge is something which we sometimes do not think about, and that is being an ethical organization, and especially in the privacy, in the global privacy playing field today, is becoming extensively and ever increasingly more important. Privacy in South Africa is young. It's a grudge purchase at this stage in South Africa. If you see the progression of privacy overseas, especially in the EU, 3 years down the line now with GDPR, privacy is becoming a key point around which compliance and around which competitiveness is also resolving. So hopefully in South Africa at some stage, our privacy compliance will stop being a grudge purchase and become part of, it is what we do. It's part of the core values of us as an organization. We do so because we want to protect your personal information. We do so because we respect you as an individual, as a company. We do so because of the fact that it is what we do and who we are, is to protect personal information. Then also, obviously, your security and cyber attacks is always there. We don't want it to be there, but unfortunately, we need to make sure that we are also on that front protected, because cyber attacks is increasingly or exponentially increasing on a daily basis. So that's basically how, in my view, how all of this links together and how privacy filtrates or permeates through this the whole time. What does privacy mean for, or what does POPIA mean for the ethics practitioner? Well, let's look a little bit more closely at what is the ethics practitioner's duties in this regard, and how can ethics practitioner also participate in this. So what is the relationship between the law of privacy and ethics? The answer lies in the preamble to POPIA. Now, if you read the preamble to POPIA, you will see that POPIA says very clearly there is a balancing right to process personal information against other rights, such as the right of access to information. And the protection of the free flow of information is extremely important in terms of POPIA. So where you would find in the last week or so, you get these notices the whole time about people saying that you can't process my information, you don't have my consent to process my information. If you don't give consent to processing information, then we will stop doing it. We would see that this is stifling the free flow of information. And that is not the intention as is described in POPIA. The free flow of information is the underlying right, and the access to information is the underlying right that a responsible party and a data subject has. And the Act regulates the manner in which personal information may be processed. It does not say you may not process personal information unless you have my consent. So the importance lies in the regulation of processing, not in the prevention of processing. And it is here in the regulation of processing, therefore, how do we process personal information, that ethics, in my view, becomes so extremely important, because it is the regulation thereof, the way in which we do it, and the way in which we act towards a data subject, that we are now basically having a role for the ethics officer. So law of ethics and compliance, in my view, are closely interlinked in POPIA. It is not only compliance, it is not only legal obligations, it is also how do we do it as a company. So how dear is your reputation to you? You can go and look at international precedents. You have seen in the media the exorbitant fines that has been leveled against Facebook, Google, big companies, airlines. It is extreme amounts. I don't think it will become that extreme in South Africa, or I hope it won't become that extreme in South Africa. But how dear your reputation is to you is probably going to be a costly exercise. Doesn't matter whether we are actually dealing with a South African environment where, for instance, your dignitas is not as expensive. If you look at court cases about your dignity, because that is something which you can claim under POPIA. You can get non-patrimonial damages under POPIA as well. So it's not only the cost that I had to protect myself against this privacy violation, it is also the reputational damage that I suffered as a data subject that I can claim. And the court can grant a judgment against me for patrimonial as well as for non-patrimonial damages that I suffer, for instance, my dignity that has been attacked. Now, from a responsible party framework, we call it hard cost and soft cost. Hard cost, penalties and administrative fines for offences, for instance, which is in terms of the Act. Then criminal liability and warrants that can be executed. You're all aware of the fact that there is criminal liability as well as warrants that can be issued. A warrant, for instance, to enter the premises, to attach documents and information by the regulator. She can enter a premises on the face of a warrant. Criminal liability, you all know that we all was very surprised. We're not used to criminal liability in the region of 10 million rand. Then your civil liability, as I've said, in terms of Section 99, which is your patrimonial and your non-patrimonial. And then the Act also talks about aggravated damages. So you can be punished. You can get a punitive order for damages against your company when it comes to the hard costs that can be ordered by a court of law. Then your soft costs, obviously, is your ethics and your values that are declining. We all know what the effect is of a decline of ethics and values in an organization. You know exactly what happens when there is a value loss. There's an ethical drain in your organization, and the effect that has on employees, the effect that has on misconduct that is increasing as a result of this ethical decline. The mining industry in South Africa is, for instance, and the building industry are two industries in South Africa that has been criticized a lot for criminal behavior. Well, not criminal behavior, but for a decline in ethical values and the result in fraud and corruption that takes place. Then the loss of trust, obviously, by employees, by external stakeholders, by shareholders, the loss of respect and reputation, and then the resulting unlawful activities, because if people are unlawful, they are known to be unlawful. A company is known to tolerate unlawful activities, you will find that there might be an increase. And then obviously the loss of clients and stakeholders as a result of that. Now, ethics and the Act calls it interference with the right of data subjects. So what are we talking about? POPIA talks about an interference, and then interference can be various things. And again, here you will see how interference is a word that's used by POPIA, and it's specifically, in my view, chosen by the regulator not to use the word violation, for instance, or breach. You are not only violating the right or breaking the right of privacy of a data subject, obviously is part thereof, but it is an interference. It's a lighter test, in my view, that will be applied by the courts and by the regulator, where your unethical conduct of an organization can be seen as an interference in terms of POPIA, in my view. That is where any of the 8 conditions of the Act is breached. For instance, one of the 8 conditions is openness, condition 6. So if you process the information, you are entitled to process the information by contract, by way of any of the exclusions, or even if you have consent to process that information, but you are not open about that, then you might be in breach of one of the 8 conditions, and it might be an interference. It's not a criminal conduct. Nobody has committed any criminal or civilly, well, it can be civil in terms of Section 99, but not necessarily a criminal conduct. But that interference with the right, your interference with your right to information, your interference with the right to be informed that your information is being processed, is an interference as defined by the Act. So we should understand that I think the test of an interference is not going to be necessarily a civil violation or a criminal violation that is punishable by criminal law, for instance. Then the next one is not reporting a security compromise. So there's a security compromise of the information. If you don't report it to the data subject, or you don't report it to the regulator within a reasonable period of time, then it is an interference with the rights. Then unauthorized access of personal information, cybercrime, theft thereof, or if you do direct marketing, contrary to Section 69, or if you make an automated decision that has a direct result or can have a negative result on a data subject, contrary to Section 71, or if you transfer data trans-border without informing the data subject, or getting consent or having rules, corporate binding rules or an agreement in place, or if there is no similar legislation or regulations in place, then you're acting contrary to Section 72, that's an interference. And if you're acting contrary to a code of conduct that might be applicable in that specific industry, then all of that is an interference in terms of the Act, which is very much, in my view, also linked to unethical conduct, or unethical conduct can even go as far as being an interference. Now, how will the regulator determine this or apply this? The Act says very clearly that the test that is applied is a test of reasonableness. So you can be held liable for criminal conduct, for intentional conduct, or for negligence. And the test that will be applied is, what did you as a responsible party do in order to make sure that you are reasonably acting to protect the personal information of the data subject? And that reasonable test will determine how big is your fine. It will determine how big is the damage that that responsible party might get from a court from you. So in the instance, for instance, that we looked at, that company immediately informed the data subject. That company immediately stopped the processing or the publication of the payroll information. They took steps immediately in order to do so. So what would be the effect of the unethical behavior on the test of reasonable compliance? Here, I think very importantly, if the information, if the conduct is of an unethical nature, and that unethical nature is attributed to negligence or can lead to negligence as a result of that, or if the unethical environment within the organization leads to negligence, you might find, in my view, that your damage that a data subject may suffer as a result of that can be higher. Or if there's unethical conduct that's also in here, remember the court can give a punitive order also against the responsible party. It might be that there is a punitive order made because of the fact that the conduct here was also unethical, or there were unethical behavior surrounding the negligence or the intentional conduct of a party here. So in my view, very important that it is possible that the unethical behavior of an organization can have a detrimental effect on the test of reasonableness, because the test of reasonableness have not been defined in our courts yet. The test of reasonableness has not gone to our courts because POPIA is new. Privacy, in my view, has got an intrinsic social nature, and how you act as in a social environment, and how the unethical conduct of a institution on a social nature is actually very important in my view, and can have a detrimental effect. We will have to see what the courts do. We will have to see what the regulator do in this regard. So how can the ethics practitioner support the information officer? So this is something, if you look at the duties of an ethics officer, I've asked myself, where do you play a role? The ethics officer might receive an appointment to act as an information officer, or not an information officer, a deputy information officer, because of the position that you have. If your ethical department or your ethics positions are part of your risk and compliance, for instance, which it is in most instances, then that ethics officer will be part of the execution and the implementation of POPIA and privacy, and very importantly, also in my view, should play a supporting role to the information officer and the deputy information officer. So here is, for instance, a very golden opportunity for the ethics office in an organization or in a business to actually support the information officer, to play that watchdog role and to play that supporting role. And instead of being reactive, in order to reactively deal with ethics information, to do with reactively be part of an investigation, whether it's an internal investigation, whether it's a forensic investigation, is to be proactive in order to assist the organization or the company to have ethics as part of the golden thread, and privacy protection as part of that golden thread that runs through the framework and the heart of an organization. So your information officer is a statutory appointment. This is peculiar in South Africa in the sense that in GDPR, there's no criminal liability, so nobody goes to jail. However, in POPIA, there is criminal liability and somebody must go to jail. So somebody needs to be directed by the Act, and this is the accountability in terms of Condition 1, which lies on the shoulders of the information officer, who is appointed by law. You can appoint another person to do or to take on the responsibility and the functions of an information officer or a deputy information officer, but you cannot contract out of the accountability which is placed on the shoulders of the information officer. So what, in my view, are some of the duties? If you look at section 55 and 56 of POPIA, it is to encourage and to ensure compliance with the 8 conditions of POPIA. And the Act here says encourage and ensure compliance with the 8 conditions. So how do we do that? Remember, right in the beginning, I referred to your policies and your procedures. So here the ethics officer can play a very important role to make sure that ethics and privacy are part and parcel of the policies of a company, and to make sure that what is the maturity framework of our policies and our procedures? How often are our employees trained on that? It's one of the duties of the ethics officer also to make sure that employees are continuously trained, new employees are trained. If you have induction programs, that new employees will go through the induction. That a policy is not a document that gathers dust in file 14 or file 13 in a manager's office, but that it is part of how do we live privacy, how do we live ethics in an organization when we talk about protection. So ethics by design is something that you can ask yourself in your organization. How can I design ethics to be part of our privacy? We have privacy by design, which is part of GDPR. It's not part of South Africa, but the regulator has also said, well, if I can use international standards, the Act allows for me to use international standards. So why should I write ethics or privacy by design into the law books? I've got international precedents, so I'm sure it will become part of our South African framework as well. So we design privacy programs and we design privacy specifically for our organization. Ethics is the same type of thing. How can we make sure that ethics and privacy are linked together? When we design privacy, we also make sure that what we design is also ethical, because ethics is part of our framework. And then also very important to deal with requests. Especially when you deal with forensic reports and recommendations coming from the reports, you can deal with requests that comes from or assist the information officer to deal with requests that comes from data subjects, assist with processes, keeping records, which may be requested by the regulator because she may institute investigations into your privacy practices. She may ask for proof of certain privacy practices, and it's very important that those privacy practices are recorded. Another example would, for instance, be health records, where you may refuse proof, may refuse health records where it may cause serious harm. For instance, where there is proof or where it requires proof of measures such as counseling before the health records can be made available to the data subject. So there are so many interlinks between transparency, between participation, and between ethics, which are two of the conditions of POPIA: participation, data subject participation, and openness and transparency, which is part and parcel also of what you can do and how you can make those principles applicable and support an information officer or an information officer's office in this regard. Investigations is another one where the regulator might request you to work with them on investigations that can be going on in your environment. And this is also specifically, for instance, where prior authorization needs to be obtained This is where you make use of unique identifiers, and where unique identifiers is used with other information, where you process criminal, unlawful, or objectionable behavior on behalf of third parties. So if you are part of a forensic investigation team, that forensic investigator who's processing criminal and unlawful or objectionable behavior on behalf of your company needs to obtain prior authorization with the regulator. That has now been postponed, or the implementation thereof has now been postponed to the 1st of February next year, unless there is a code of conduct. So now is the time, if you want to start looking at a code of conduct to regulate this specific prior authorization issue in your industry where you are operational in. Now is the time to start looking at that. And then also, if you do credit reporting, or if there's trans-border flow of special personal information, that's for instance your medical information, biometrics, your union membership, political opinion, all of that are special personal information. When that is transferred across border, then you need special prior authorization from the registrar. So here's a lot of administrative functions where you can also assist to make sure that this is done in time. The regulator has got 4 weeks, for instance, to let you know whether they are going to give prior authorization or whether they're going to investigate. They've got 13 weeks to investigate. By that time, the criminal is long gone with all the information and there is huge reputational damage. So how, from an ethical perspective, are you part of this privacy team, so to say, in order to make sure that you actually act as a watchdog, also looking after privacy as part of the ethical duty as well. The ethics practitioner will have to work closely, in my view, with the information officer and the deputy information officer if this becomes part of your job description or as part of your portfolio within a risk and compliance department. Therefore, you need to understand the liability and accountability of the information officer and the deputy information officer. If you are the information officer or the deputy information officer, look and reach out to your ethics people in your organization, because they can add a lot of value in this process of keeping privacy safe. And then also guidance, therefore, when is consent required, and the ethics surrounding the processing without consent. This is, in my view, a very important role that an ethics practitioner will also play, and that is consent, because consent imposes knowledge. I may not need your consent because I've got an exclusion reason as to why I'm processing your information. However, the fact that I don't need your consent does not mean that the openness and the data subject participation part of the Act does not apply. So although I may process your information without your consent, I still need to inform you that I'm processing your personal information, and I need to give you participation if you request such participation in order to process your personal information. So how far, as from an ethical perspective, do I need to get consent? Is it the view of my organization, for instance, that if I don't need consent, I won't ask consent? Or are we going to say, listen, when we process personal information, we are first going to get consent. Only if we can't get consent, or there's a practical reason why we can't get consent, we're going to revert to the exclusions. What is the ethical way of dealing with processing of personal information? It is still the personal information of a third party. And consent also, when we talk about consent, remember also, consent is the voluntary, specific, and informed expression of will. It is not by default. To what extent will it be explained to the data subject to ensure informed consent? This is again, in my view, an ethical question as to how far will we go as an organization to make sure that people know and understand what they are consenting to. And how do we marry that with our business requirements? Because don't get me wrong, I'm not saying here that you need to add a huge administrative burden on an organization that is going to make the organization dysfunctional as a result of this. The reality is, this is what the Act requires of us. And the reality is, that it is also an ethical question as to whether we inform a data subject and whether we get consent or not. It is so closely interlinked, in my view, to the communication and the openness condition in POPIA, to name just two of them. The information officer must appoint deputy information officer, which must be an employee or a senior member of management or higher. So work closely with those people. This is, for instance, information that we're getting from the guidelines that the regulator posted on information officer. And this works against the contracting out of the functions of the information officer, because we require the information officer to know the intricate workings of an organization. And this is where the privacy practitioner can also provide very valuable input to the information officer or the deputy information officer, where, for instance, a deputy information officer is brought in as a consultant, for instance. Regulation 4.1 then also added additional duties to Section 55, which is part of the workhorse part of the Act, and that is developing the personal information impact assessment, or the gap analysis, to make sure that there's a manual and make copies available on request, to make sure that there's a compliance framework that is developed, implemented and monitored, flowing from the personal information impact assessment, and to make sure that internal measures and systems to process the request of personal information or the access thereto is kept in place. So how do we do that? Where, again, you need to ask yourself in your organization. Obviously, these functions will not necessarily fall on the shoulders of the privacy practitioner. However, this is something where you would very closely work to it. For instance, internal awareness sessions. What is the right thing to do in this organization from an ethical perspective, not only from a privacy or a legal perspective? Now, some critical considerations, hopefully, that I have put in your mind that you need to look at and that you need to consider and broaden your mind when it comes to what is your role? Where are you today on the 8th of July 2021? It is 1 year and 8 days post the implementation of POPIA. Where is your organization? Does your organization embrace privacy and ethics as part of its corporate responsibility? This is where the social part of the Act becomes extremely important. And it's for each and every organization to answer to this question. The law has got a stick, and it will hit you with quite a hard stick, with quite an extensive fine if you do not do that. But there is far more applicable here than just an act of compliance with regard to our duties as a company when it comes to privacy and our legal obligation when it comes to privacy. It's also about our reputation. It's also about our values. It's also about our ethical stance and what is the right thing to do. We need to get together as corporate citizens and do the right thing. And privacy, in my view, and ethics are most definitely the right thing to do. I'm sure I don't have to convince you about that. So thank you very much. That is, with 5 minutes to spare, that is the presentation. I don't know whether there were any questions, Stefan, that we need to deal with. Obviously, if there are too many questions to deal with in this last few minutes, I will be quite happy to answer questions on emails as well. I know that people still have got a lot of questions to ask.
Sure. Thank you very much, Johanette. I mean, absolutely fascinating. And I mean, just thinking about the issues that you raised is, you know, it's kind of both exciting and also very scary if you look at the severe consequences. And I think it reminds us just a little bit more about our own responsibilities in this. And something that's quite prevalent for me is like, you know, there's two perspectives here, and very interesting. You call it social legislation, and I tend to agree with you. I mean, when you see at the latest kind of pieces of legislation that was promulgated in South Africa, I mean, when you look at acts like the Consumer Protection Act, I mean, some of the treating clients fairly regulations and the latest kind of consumer-centric legislation. I mean, it comes to the fore that the regulator tends to start blurring the lines between a very rule-based framework versus a value or an outcomes or a principle-based framework. Yeah. And those lines seem to blur. And I think that's why it's very important to those of us who think that POPIA is just a piece of legislation and it's for the lawyers and it is for the compliance officers. I think it's a bit of a reality check, given that it is not, as you correctly positioned it, and that there are very much a different perspective to it. And I think that's very important. Also, I think for us as ethics practitioners, it just shows that we fulfill a very important role in this, in that, you know, we should support the information officers and we should support the compliance officers and the legal advisors in the process and give a different perspective to this, so that, you know, mere regulatory compliance to POPIA is not the purpose and not the goal, that it goes a little bit further, that, you know, that may be the bare minimum standard, but that we as ethics officers should push further and increase the goal to doing the right thing, and that mere regulatory compliance is just the bare minimum, and play a very specific role. I mean, most of us fulfill in some way an ethics practitioner role or function inside of our organizations. And what is expected from us more and more is an advisory and a consultancy role. You know, the days of just managing safe reporting mechanisms and hotlines and all of that is far gone. And we're more and more required to fulfill a consultancy role. Some of our members are also are practitioners in their own right, and you know, assist big companies with this. So the important thing I take out of it is that in terms of privacy and security and trust, the role of the ethics practitioner is more important than it ever was. I mean, we facilitate many of the company values along security, trust, integrity, fairness, all of those kind of intrinsic values come out. And this is all intertwined. It's very difficult to separate these kind of components from each other. And it highlights our role more and more. Very, very, very scary thought actually to think of it. I don't know if there's any questions. I see there's a question. I don't know, that was just a comment from Megan. I don't know if there's any other questions before we break. I think there's another minute or so left. You know, while we waiting, I think Johanette, what's important here is maybe this kind of play between the rights of the consumer and the rights of the company, and that is this balancing act that I think is never going to go away. I mean, you'll have the regulation and the legislation and all of that, but for us as ethics practitioners, you know, the whole way of critical thinking and analyzing, you always have these balancing act between different rights of all the stakeholders. Do you think that will change in any way going forward, or do you think that you know, that kind of balancing act will always be there? I don't know if you've got any comments around that.
I think the balancing act will be there, but I think also the deck is being stacked up by POPIA against the companies as well. I hope that at some stage in the future the regulator will consider that, because POPIA regulates personal information and to a great extent confidential information of legal entities. And for me, that opens up quite a big risk, because, you know, if you look at GDPR concerns itself with the natural person. So that would be your employees predominantly, people that visit you. But now suddenly in your commercial environment, and now you're talking about a customer, that person, that legal entity is also now protected in terms of personal rights under POPIA. So I think the balancing act sometimes I think is being stacked a little bit against the responsible party or the companies here, because of the fact that we've got this added liability here also. So now suddenly our emphasis, for instance, is now on your contracts department, on your consumer department, on your commercial departments, on marketing, because it's the people that you market to is not just the individual that picks up the phone. The information that you process is also, now when I receive an invoice, if I send you an invoice, I am now a data subject just because of the fact that I've sent you an invoice from my company, whereas it should only actually be, if you look at personal rights, it should be about me as a person, but now it's also about corporate, not corporates, about legal entities as well. And I think there is quite an extensive obligation that's been added under POPIA that we don't have under a lot of other privacy jurisdictions. So more and more onerous, I think, than less onerous.
Yeah, thank you. I mean, Cynthia, I think we kind of run out of time, but maybe just one last question but I think we answered it to a large extent from Kali. To what extent does POPIA shift the ground for ethics practitioners' role in organizations? I think, Johanette, we kind of covered that to some extent, and if Kali, you need more information, we're happy to discuss it further. But I think essentially, the involvement of the ethics practitioners is required more than ever in terms of POPIA and these privacy legislation. So I mean, Cynthia, if it's okay with you, I think let's conclude. Johanette, I want to thank you very much. I know the time is scarce and we all battle for time, but I really appreciate. And I think from the EPA perspective, the board really is appreciative of your time and your input. And what we'll do is I will, for our members that still have questions, I will make available, obviously with your consent, your contact details. So if there's any further questions, I'll relay that. But thank you very much for the opportunity to meet you. Thank you for the opportunity to share your skills and knowledge with our members. And then I want to conclude and just wish you well and all the best. And looking forward to a very fruitful partnership with you and your associates. Thank you very much.
I really enjoyed it. Thank you.
Thank
you for having me.
Okay. Okay, ladies and gentlemen, thank you for that. Thank you for joining us. I think that concludes it for today. All the best. Enjoy your day. And obviously, as I said, if there's any remaining questions, relay it to send it to us and we'll relay it to you, Annette. And let's keep the conversation going.